Do sit down, everyone, except for Mr. Latham. Yes.
Thank you.
Good morning.
My Lords, good morning. I appear on behalf of the appellant with Mr. Barnes, and then a friend, Mr. Ralph, appears with Mr. Kay on behalf of the defendant respondent. Yes. My Lords, if I may, I'll start by drawing the Court's attention to the permission order, the order granting permission to appeal in this matter, which is in the appeal bundle behind tab 6, page 46.
Yes.
Your Lordships will see that this order made by Lady Justice Appellant granted permission in respect of 3 key issues. Firstly, the application of Part 36.17 of the CPR, where the claimant is a minor and approval of an agreement is required. Secondly, the application of Part 36.17, where the offer is in respect of liability only. And thirdly, and I say most significantly for today's purposes, whether, or rather to deal with the important principles and points of practice arising in relation to the High Court's decision of Mrs. Justice Collins Rice in Mundy. The decision in Mundy, I think it's fair to say, has caused a quite considerable concern across the profession. And as Lady Justice Appellant noted in giving permission, it appears to clash with other authority and some of this court. On that basis, I hope your Lordships will forgive me in the circumstances for starting with Mundy, which is slightly out of turn from the skeleton argument drafted by those instructing me, which was lodged and prepared prior to my instruction. So Mundy is in your Lordships' authorities bundle at tab 1. The facts of the case may be briefly stated. It was a holiday sickness claim brought by Mr. Mundy against TUI, the holiday company. 3 significant features of the chronology. First of all, the claimant made a Part 36 offer in November of 2018 on the issue of liability to accept 90% of the full value of his claim. It's referred to as the 90-10 offer throughout the judgment. The second is the defendant's Part 36 offer made 12 months later on November 2019, which was an offer to settle the whole of the claim for £4,000. And then finally, the trial took place in May 2021. At that trial, the defendant was held 100% liable for the claimant's injuries, and those damages were assessed in the sum of £3,805 and some pence, so just under £200 less than the defendant's offer to settle the claim. So the situation in Mundy was slightly unusual in the sense that, not wholly unusual, but slightly unusual in the sense that both parties achieved an outcome which was more advantageous than their respective Part 36 offers. Page 12 of the authorities bundle, paragraph 26. Mrs. Justice Collins Rice began to analyse what she described in the heading there as the rejected 90-10 liability offer.
Was it a fast-track trial?
I suspect it was, given the value of the claim. I can't see that that's mentioned in the judgment, but at that value, it almost inevitably was a fast-track claim, my lord.
Claim seeking general damages between 25 and 35,000, according to paragraph 1.
Yes.
Sorry, you were saying?
No, not at all, my lord. I was just thinking back. I suspect at the time, it's not clear when the claim might have been intimated, but I suspect the intermediate track didn't exist at that point in time, so it would have either been fast track or multi-track, and this would have fell well within the fast track limits. Excuse me. My Lords, turning back to paragraph 26, where Mr. Justice Collins Rice's analysis begins, she agreed, or rather counsel before her had agreed with Mr. Justice Foxton, who granted permission, that offers of that kind, liability offers, had become, quote, widespread. Counsel, you'll see in the second sentence of paragraph 26, were unaware of any existing authority on precisely how those offers fit into CPR 3617 if they are rejected. And I'll say in due course that that's a significant feature of this judgment. There are a number of authorities which do deal with that question. And to that extent, the learned judge's decision, I say, was reached in per curiam. Paragraph 27. Your Lordships will see that Mr. Pennock, who acted on behalf of the claimant, explained the general mechanics of Part 36, and that a claimant who is confident of success on liability could make a Part 36 9010 liability offer to induce the defendant to concede liability and agree for the case to proceed to trial on quantum alone. I don't propose to read out to your Lordships the rest of paragraph 27, but it's a basic review of the purpose behind 36.
It's a legitimate aim.
Forgive me.
It's a legitimate aim.
It is a legitimate aim.
To encourage settlement of issues, if not of the whole thing.
Indeed. But my submission entirely.
By the looks of things, that's common ground. Yep.
I'm grateful to my own friend. Your Lordships will see at the end of paragraph 27 that Mr. Pennock described this legitimacy aim to incentivise parties to make offers and to have consequences in costs if offers are rejected, but then an outcome which is more advantageous is obtained at the conclusion of the case as the carrot and the stick. And Mrs. Justice Collins Rice comes back to that phrase towards the end. So I flag it now for your Lordship's note. Excuse me. Paragraph 29, your Lordships will see that Mr. Pennock explained just how confident on that case the claimant had been of a liability win, and at paragraph 30 that Mr. Mundy had been proven right. He won on liability 100%. It was said that that establishes that Chewy's rejection of the 9010 offer was unreasonable and put the parties to the unnecessary trouble and expense of a trial. Turning then to paragraphs 31 and 32, most significantly, paragraph 31, the learned judge said the mechanics of that proposition rely on fitting the rejected 9010 offer into the wording of 3617(1)(b). And at paragraph 32, the learned judge found difficulty with that, saying that it cuts across the binary structure of Rule 3617(1) by contemplating a situation in which the answer to both limits could be yes, the claimant having failed to beat the defendant's money offer but still having equalled or beaten his own liability offer. And she concluded that that raises a problematic prospect of both subsections 3 and 4 applying simultaneously. She concluded that in circumstances where it was far from obvious that this is within the contemplation of the rule at all. In my respectful submission, those difficulties as might exist, and we'll come on to examine them in a little more detail shortly, were overstated by the learned judge. They were not.
Well, any rule which provides, as 36(2) does, for offers to be made in relation to distinct issues.
Yes.
You can have a number of offers in relation to a number of distinct issues.
Yes. The prospect of simultaneous success on different issues is, in my respectful submission, an inherent part of Part 36. Yeah. And to the extent that the learned judge considered that to be problematic, I say respectfully she was wrong.
Yes. And offers in relation to issues will often not be a money sum. You can't make an offer in relation to the issue of liability, which
yes.
is couched in terms of money.
Indeed.
And so the rule must anticipate that you can make an offer on an issue other than by offering some money.
Pounds and pence, that's right, my lord. I accept that entirely.
And there's nothing to stop people doing sort of either composite or contemporaneous offers, saying, for example, 90/10 on liability and 3,500. Another offer saying we'll accept 3,500 to settle the claim.
My lord, yes, that would be, they would be two distinct offers, one to settle the whole of the claim.
And I mean, I'm talking from slightly ancient experience now, but that happens, doesn't it?
It happens all the time, my
All
lord.
the time.
All the time. That is the...
Because people are trying to settle.
Because people are trying to settle. Entirely right. And it's entirely ordinary for offers to be made in respect of individual issues. But liability is the obvious non-monetary offer that might be made routinely where there is a dispute in respect of liability. And in the bundle, and I'll come to them very shortly, there are a number of examples of that in practice. There was a matter of Welsh before Mrs. Justice Yip, as she was, where an offer was thought to accept 80% of the causative effect of two particular aspects of a clinical negligence claim. So far more complicated than the straightforward 90/10 liability offer that you have here, where there's a straightforward injury and liability is denied, and the offer is to accept 90% of the whole.
I think one thing that one must recognise, and I'm not sure whether it comes out in Monday, is that, of course, the offer in relation to the issue only governs the cost of the issue.
Well, it's not dealt with in Monday. There are two authorities in the bundle which tread on this issue. The first, excuse me, is Webb. It may assist your lords if I take you there now.
Well, up to you. Can you at least give us the names of the cases you're referring to now?
Yes, forgive me.
If you want to postpone them for a little while, let you know what you have in mind.
Yes, of course. The case, the two cases are Webb against Liverpool Women's NHS Foundation Trust, which is at tab 10 of the authorities bundle, and the other case, which perhaps suggests an alternative approach, is London Trocadero LLP against Picture House Cinemas at tab 14. Perhaps, if I may, I'll put those to one side just for the moment and continue with the analysis of Monday, because they arise as a result of some of the observations made by Mrs. Justice Collins Rice in that case.
And what was the Mrs. Justice Yip case?
Sorry, that was Welsh against Walsall Healthcare NHS Trust. Yeah. That's behind tab 4 in the authorities bundle.
Right. Keep going with Monday.
I mentioned that I don't have tabs in my bundle.
Oh, I do apologise.
So you'll have to tell me the page numbers.
I will tell you the page numbers. So Welsh is at page 57. And to complete the set, for want of a better phrase, Webb is at 142. London Trocadero at 199.
Thank you.
So, as my Lord Phillips has already identified, the nature of Rule 36.2, which enables parties to make offers in respect of individual elements of a claim, gives rise to an infinite variety of issues against which offers may be made, some of them monetary, some of them not monetary. And a rule which explicitly anticipates offers in respect of a part of a claim or in respect of any issue arising that claim, I say must inherently anticipate this possibility of simultaneous success. That's a matter of an analysis of the plain language of Rule 36.2. Excuse me. Even more basically, on any view, a percentage offer is precisely that. It's an offer to compromise an element of the claimant's claim. And it's difficult to see why that concept ought to be construed more restrictively, as Mrs. Justice Collins Rice, ultimately went on to interpret that offer, than any other type of Part 36 offer. Paragraph 35, so I was on page 14 of the authorities bundle in Monday. At paragraph 35, counsel for Mr. Mundy submitted that the offers should be reconciled, taking each chronologically and then and obviously sequentially. And the judge indicated in paragraph 35 that she didn't find that a submission which was straightforward to follow. She went on in paragraph 36 to say this in the first sentence: a 90/10 liability offer is not straightforward to recognise as an offer to settle a whole claim on quantified or quantifiable financial terms in a case where there is no genuine question of issues-based liability.
What does that last phrase mean?
Well, I'm afraid I can't assist, my lord, with that, because I've struggled to understand precisely what that sentence is intended to say. By its nature, a liability offer is not an offer to settle the whole of the claim, but nor does it have to be under the terms of CPR 36.2. What the judge goes on to do is to defeat Mr. Pennock's attempts to rely on the terms of Part 36.2, which are referenced in paragraph 36, by concluding that liability is not such an obviously distinct or severable part or issue capable of being given a monetary value. But in my respectful submission, that must be wrong. It's precisely, and probably, in my respectful submission, the easiest and most severable aspect of most pieces of civil litigation, to sever the question of liability as a distinct issue in the claim.
How long is a case like Mundy or this, where liability and quantum are an issue,
yes,
at these sort of levels, how long do they tend to be listed for?
Certainly this case, the Smithstone case, was listed for a day.
A day?
I suspect Mundy was the same. That would be ordinary and fast-track litigation, trial no more than a day.
Getting nods on the other side. Thank you.
At the very bottom of page 14, I pick up halfway through the line, the last line. A 90/10 liability offer does not appear in a case like this to attempt to estimate or predict any split liability orders a court may make in a given case, unless split liability is a genuine prospect on the facts of a case, and the example given is a road traffic accident. A 90/10 liability offer looks, if accepted, like a complete concession of liability in return for a financial reward, a share of the quantum. Again, respectfully, I've struggled to follow the final part of that sentence. But to the extent that the judge seems to be saying where a split liability decision would not be one open to the court in the event of a trial, in other words, this is an all or nothing case, then a liability percentage offer could not possibly have any effect under Part 36.
That's directly contrary to Huck.
It is. I can take your lordships to hook. That was my intention.
I in due course, could you?
Very good.
The fact that Lord Justice Stuart-Smith's knowledge of the authorities is he knows them all by
Well, just
heart.
as I know why.
we don't all necessarily.
Very good.
And anyway, that one is this court, isn't it?
It is this court. I'll take your lordships to it now. It's behind. Sorry, I'm giving you the tab numbers again.
Sorry.
It starts on page 156. Now, my lord, I ought to offer some broad observations first, because Hook is an interesting case in this respect. The lead judgment was given by Lord Justice Jonathan Parker. From paragraphs 1 to 49 of his judgment, which is the lead judgment, he sets out the background to the appeal, the applicable procedural rules, and the summary of the party submissions. Between paragraph 50 and paragraph 62, he disposes of two issues. The first of which is one raised in the respondent's notice in that case, as to whether or not an offer should have been taken into account as a Part 36 offer because it was made pre-issue. His conclusion is that it should, and both of the other judges in the panel agreed with him on that point. After paragraph 62, he goes on to deal with what I say is the pertinent question for the purposes of this appeal. And he reaches a conclusion on the effect of the offer in that case, with which his brother judges disagreed. So I'll focus on the majority judgment rather than Lord Justice Jonathan Parker's minority judgment, and that starts on page 170 with Lord Justice Tuckey. And my lords, at paragraph 69, he says this: I think it is clear that the judge deprived the claimant of indemnity costs, which was the effect under that Part 36 at that time, simply because liability would never have been apportioned 95/5. Lord Justice Jonathan Parker says that this was within the judge's discretion because such an offer did not create any real opportunity for settlement in a case where there was no real possibility of an outcome other than 50-50 or an outright win for the claimant. Lord Justice Shyman says the fact that no judge would apportion liability 95/5 is irrelevant. A defendant can choose not to accept an offer, but if the claimant beats it, there is nothing unjust in awarding indemnity costs. I think Lord Justice Shyman is right about this. I do not think that the court is required to measure the offer against the likely outcome in a case such as this. In this type of litigation, a claimant with a strong case will often be prepared to accept a discount from the full value of the claim to reflect the uncertainties of litigation. Such offers are not usually based on the likely apportionment of liability, but merely reflect the reality that most claimants prefer certainty to the ordeal of a trial and uncertainty about its outcome. If such a discount is offered and rejected, there is nothing unjust in allowing the claimant to receive the incentives to which he or she is entitled under the rules. On the contrary, I would say that this is a just result. And to the extent that it adds anything, paragraph 82 of the judgment, which is Lord Justice Shyman's section of the court's judgment on page 172, he says, unlike Lord Justice Jonathan Parker, but like Lord Justice Tuckey, I consider that in the present case, the judge approached the exercise of his discretion on a wrong basis. The judge was unduly influenced by the probable fact that no judge, if the case came to trial, would decide that liability should be split 95/5. I regard this conclusion, although correct, as irrelevant. We are therefore entitled to exercise this discretion afresh. Now that Court of Appeal decision obviously bound Mrs. Justice Collins Rice, but she wasn't taken to it by counsel, that she gave her judgment in ignorance of it. Similar conclusions were reached at a number of cases which are cited in the appellant's skeleton argument at paragraph 53. In an effort to comply with the practice direction, I haven't included all of those authorities in the bundle, but for your Lordship's reference.
Well, just a minute. You've said it there at 53 of your skeletons, so rather
Yes,
than reading out citations, let's just have a look.
Yes, it's on page 34 of the appeal bundle.
Except for Huck, they're all first instance.
Yes, all first appeals.
All first appeal.
Yeah.
Yes.
So
Do they all follow Huck?
they all follow the same principle. Oh, forgive me. In terms of time, yes, they do.
Well, in both senses.
In both senses, yes.
Yeah.
Obviously, the nature of the offer is slightly different in some of them. Some of them are 90-10, the same as this case. Some of them 95-5. So, in my first submission in respect of Mundy is that it was wrongly decided on that point, certainly because it runs contrary to both the Court of Appeals, this court's decision in Hook, but also contrary to established litigation practice. Such offers, as was made in this case, are routinely made and accepted across the spectrum of civil litigation. Settlements are, in relation to liability, are often approved where the claimant is a child as well, and that's a point I'll come back to in due course too. So returning to Mundy at page 15. I left off at the top of page 15. Whereas I'll pick up at paragraph 38 in the middle of the page. And this is the second strand of Monday that I say with respect that Mrs. Justice Collins got wrong. She says there that on a plain reading, Part 3617 1A and B are directed to a like-for-like comparison. And this concept of a like-for-like comparison is a concept to which she returns repeatedly through the balance of the judgment. She says both limbs are directed to the quantified money terms on which either party offered to settle the proceedings, the whole of the proceeding. It's an entirely simple instruction, she says. That plain reading of CPR 3617 as being directed in a case like this to quantified money offers is supported not just by its own internal logic, but read together with 3617-2 by the logic of the rest of the CPR 17. This is I won't read out the rest of that paragraph, but your lordships will see that this is in the context of considering whether or not this is a genuine offer to settle. And towards the bottom of the paragraph, 4 or 5 lines up, the line that begins, is the operative offer. She says, was a genuine offer to settle the proceedings. A single offer is referred to, either the unbeaten defendant's offer or the beaten or equal claimant's offer. The single offer must have been an offer to settle. The question for consideration by the court is then whether that offer to settle was genuine in its unsuccessful attempt.
Sorry, just a moment.
Of course. Your lordships will see at paragraph 39 that again the learned judge indicates that she was not encouraged by the parties to seek assistance from the deciding authorities. No doubt your lordships will have a view as to whether that might have been a more appropriate course of action. But what it says at the top of page 16 is the basics of how it operates are not in dispute. And there is no authority on rejected 90-10 offers. And as I've already demonstrated, that it is not an accurate recitation of the law. We say respectfully, not only was that wrong, but there are a number of authorities dealing with the rejected 90-10 offers, and it left the judge determining what was in fact a contentious issue as to the operation of Part 36 when it comes to liability offers, liability-only offers, without the benefit of considering that authority. Before I take your lordships to 1 or 2 examples of those authorities beyond Hook, at paragraph 40, the learned judge held that the 90-10 offer was not an offer to settle a quantifiable part of the claim, and that difficulty meant it didn't fit into Part 3617 and that regime at all. The closing words of the paragraph: there is a problematic degree of artificiality in all of this. And whilst I'm quite prepared to accept that in certain circumstances it might not be an entirely straightforward comparison, I do say that it rather overstates the difficulties.
Is there any binding authority on us as to how the court, the first instance court, should approach the question of costs where you have a 90-10 offer that has been beaten faced by a monetary offer which has also been beaten by the defendant? So the defendants succeeded on their monetary offer.
The simultaneous success that we saw.
Is there any binding authority?
No, not on those facts.
You're hoping to get some?
I'm hoping to get some.
Yeah.
There is some binding authority in respect of what a court at first instance ought to do when the liability offer is beaten. And there is obvious, to the extent that it might be necessary, authority that deals with the circumstances where an offer to settle the whole of the claim is beaten by the other side, but not an authority that deals with both of those circumstances. In fact, if I take your lordships to the case of this court in Webb, paragraph 140, excuse me, page 142. The recitation of the facts, which will assist your lordship, starts on page 145, paragraph 3. Now, I ought to draw the court's attention to the fact that in this case there wasn't a dispute between the parties as to the effect of the Part 36 liability-only offer. But I do say that it's, there is some value in considering the way in which it was recorded in the judgment, because it's very clear that this court had no difficulty with the supposed trouble of comparing a liability offer, which is in percentage terms, with an outcome at trial, which is in monetary terms. So at paragraphs 3 to 7, you'll see that the allegations of negligence fall into two main parts. It's a clinical negligence claim. First of all, that there ought to have been a caesarean section performed much earlier or at all, and not to proceed to a vaginal delivery. That's described as the first allegation. And then at little b, that the vaginal delivery itself was negligently managed because the midwives failed to adopt recognised procedures to deal with the shoulder dystocia. So two allegations of breach, but you'll see from the final sentence in paragraph 4 that the judge upheld the first allegation but rejected the second, and by upholding the first allegation, the claimant was entitled to a full recovery. So two allegations of breach, but either of which would have resulted in a 100% recovery of damages. The relevant Part 36 offer is set out in paragraph 5. October 2014, claimant made a Part 36 offer to settle liability on the basis that she received 65% of the damages that would accrue on a 100% basis. Rejected within 8 days. Then at paragraph 6, the judgment was clearly more advantageous to the proposal contained in the offer. When judgment was handed down, her counsel contended that the consequences of what was then 3614 applied, and she should have all of her costs on an indemnity basis from expiry of the relevant period. And at paragraph 7, the defendant's argument was that Part 36 didn't prevent the court from making an issues-based order. The defendant said, well, you only succeeded on one of the two allegations of breach. You ought not to recover your costs associated with the first allegation, upon, or rather the second allegation upon which you failed to establish liability. And therefore, it would be inappropriate or unjust to award the claimant Part 36 consequences. And that was the scope of the argument in Webb. The conclusions start on page 152. And before I explore those in any detail, I pause there simply to say that the parties were in agreement that the Part 36 offer had been beaten. There was no doubt about that question. And the Court of Appeal, albeit not required to determine that point, had no difficulty with it and went on to deal with it.
So the issue arose out of the fact she hadn't succeeded on her second issue.
And the question was whether it was unjust to award Part 36 consequences, indemnity costs on all of her costs, where she'd failed on one of the issues. And perhaps I don't need to take your lordships through paragraphs 30 to 38, with any particular degree of scrutiny of the decision there, because it's focused on a question which doesn't arise in this appeal. But what's clear from that judgment is that there is no difficulty with the liability offer. And indeed, it's worth noting, if we take a step back, if Mrs. Justice Collins Rice's analysis is correct, then this wouldn't apply only to those cases where a modest concession of liability is made, where it's a 5% or a 10% concession in the offer that's made. But it would apply to cases like this, where a 65% or 35% reduction has been made. And in cases, particularly in the clinical negligence sphere, it is entirely ordinary where there is a significant issue of breach and causation for parties to make very considerable liability concessions in offers, often more than 50%, in an effort to secure an agreement of liability so that some damages are recovered. And Mrs. Justice Collins Rice's approach, if it was accepted, would run a coach and horses through those offers, because they would never be of any effect and defendants wouldn't have any, or certainly a lessened incentive for accepting them.
This seems, speaking to myself, a rather obvious result. Bean's law states the reported case is always easier than the one you're trying.
Yeah.
The claimant says, I'll accept 65%. Defendant goes to trial and loses 100%. And might, even on sort of a traditional cost regime, the defendant might at best be awarded any additional costs caused by time spent on the issue on which they'd lost.
Yeah.
That would be as much as the defendant could hope to get. Otherwise, clearly the whole cost from beginning to end goes with the claimant.
Indeed.
Now, present case is not quite as clear cut, but
no, it isn't. I'll come on to that, because there are questions when we get to the end of my analysis of Monday and my submissions in that respect. Yeah. I intend to move on to the fact-specific elements of this case.
So, just so that I understand, but I'm not trying to divert you again.
No, not at all.
On the assumption that we take the indication from Huck and Webb, where you've got a countervailing defendant's monetary offer,
yes,
which the defendant beats. The question probably is, in those circumstances, would it be unjust
yes,
for the claimant to recover all their costs of liability
precisely,
because of the influence of the other countervailing factor? And is it your submission that that's the mechanism by which a court, at first instance, may make adjustments rather than just simply saying all the costs on an indemnity basis from the moment of the liability offer?
my lord's ahead of me. It's precisely that.
Okay.
The way in which it's approached in Monday is to say where it becomes slightly difficult, it's not a Part 36 offer. And that must be wrong, my submission. It throws the baby out with the bathwater. The proper analysis, in my respectful submission, is that you do have two effective Part 36 offers. Both have been beaten, to use the vernacular. And in those circumstances, the court must look at whether it would be unjust to award the claimant the cost consequences under 36.17.4, or the defendant the cost consequences under Part 36.17.3, I think it is. And the court retains that discretion, and that's the discretion that's discussed in Hook. The court retains the discretion to make a determination of costs which is just. And if the automatic consequences of Part 36 would lead to an unjust result, then some tinkering, to borrow my lord's phrase, is required.
It may be more than just tinkering.
It may be. It may be quite significant. Yes. So the one case that the learned judge was referred to in Monday is Seabrook and Adam, and it may there may be some value in my respectful submission in spending a brief few minutes looking at that. It's at page 71 in the bundle of authority. And if I may take your lordships to paragraph 5 on the bottom of page 72. there's a slightly curious feature to this case, which is that the claimant seemed to have made 2 offers, both on the same day, which both effectively amount to precisely the same thing. And that was the conclusion of the Court of Appeal at the very bottom of page 72. I needn't necessarily read out the details of the offers, but they're to accept 90% of the claim, the value of the claim. And you'll see the final sentence on page 72. It was accepted both before the judge and before us that the offers, whilst being differently worded, amounted to the same thing. A few pages forward, page 75, your lordships will find paragraph 14, which identifies what it describes as the real question, which is how these Part 36 offers should be construed. It must be interpreted in light of the pleadings, and in particular in light of the fact that Mr. Adam, the defendant, had admitted breach of duty, which had been referred to as primary liability, but had disputed causation in relation to both heads of loss. If I just pause there, the facts of this case, it's a road traffic accident. Mr. Seabrook contends that he has both neck and back injuries. Mr. Adam, the defendant, admits breach of duty for the collision, but denies the causation of the 2 injuries.
Succeeds on the neck and fails on the back.
Indeed, my lord. And at paragraph 17, the analysis of the offers is important. Both offers framed in terms of a discount on the claim for damages to be assessed. They contain no reference to the separate heads of damage in relation to the neck and back injuries. It seems to me that the reasonable reader, taking into account all of the relevant context, would construe the reference to, quote, the claim for damages, close quote, to mean the claim in its entirety, and to construe the offers as a whole to mean that a concession as to liability and causation was required in respect of both injuries. And my lords, at the middle of paragraph 19, 3 lines down towards the end of the line, beginning, nor is it, this court held, nor is it right to say that there was room to accept either Part 36 offer, but still to dispute causation in relation to either of the, or both of the alleged injuries. And so this case is quite different on its facts to the Mundy case. Also, I accept quite different on its facts to this case. But the Court of Appeal's conclusions at paragraph 21 and 22 on page 76 are of some assistance. Because in that case, on its facts, the court held that had Mr. Adam, the defendant, accepted either of the offers, it would have meant that he'd admitted liability for both back and neck injuries, would have been unable to argue subsequently that he hadn't caused the back injury at all. It follows that as he was only found liable in relation to the neck injury, he bettered both Part 36s. So this is a straightforward question of, did he beat the Part 36 offer? The answer is yes. And to the extent that Mrs. Justice Collins-Rice relied on this authority to any further degree, at paragraph 48 of her judgment, I say again, with respect, that she was wrong to do so.
What he could have done, I mean, he got the result he wanted in this
Yes.
one, but what he could have done was to make a counter offer, saying, I accept liability for the neck, but not for the
Yes.
head. Or he could have made 2 and tried to give himself cover by doing that.
But this is the value of Part 36.2 as it's currently drawn. There are a plethora of options available to a defendant in that situation. He could have offered 50% of both injuries, or some other percentage. He could have offered all of the damages related to the neck, but nothing in relation to the back. Or he could have made a Part 36 offer, which was 80% of the neck only, but nothing in respect of the back.
Or he could have made an offer of X pounds.
Indeed. And however the cards fall at a subsequent trial, then whichever line of the pounds and pence offer he made would determine success or failure. So I do say that to the extent that the court in Mundy took account of Seabrook as in some way supporting this contention that liability offers ought to have limited or no effect. I say that was respectfully a misreading of Seabrook, which was very specific to its facts. The determination not being that the offer wasn't an effective offer, or the offers, both of them identical, but rather the offers had not been beaten or had been beaten, depending on which side of the courtroom you were stood on. I signposted the case of Welsh earlier on in my submissions. If I may take your lordships to that now, it's on page 57.
Sorry, can you just pause for a minute?
Of course.
I want to look back at Seabrook. Yes, sorry, where do we go next?
In fact, forgive me, my lords, I may... Yes, forgive me, if I pick up on Seabrook for one final point.
Yes. I
ought to have made, which is paragraph 22. And this rather picks up on the exchange between my Lord Justice Stuart-Smith and myself a moment ago. Paragraph 22, cases of this kind turn inevitably on the precise wording of the pleadings and the particular terms of the Part 36. In order to avoid the kind of dispute which has arisen here, especially in a low-value claim, it's important to make express reference in the Part 36 offer to whether the offer relates to the whole claim or part of it, and this is the key part, and or the precise issue to which it relates in accordance with Part 36.51d. In particular, if the issue to be settled is liability, it will be sensible to make clear whether the defendant is being invited only to admit a breach of duty, or if the admission is intended to go further, what damage the defendant is being invited to accept was caused by the breach of duty. So it goes to the terms of the offer rather than its effectiveness. I think my lord probably had that point, but for clarity and for completeness. So I turn now to the decision in Welsh, which starts on page 57 of the bundle of authorities. The judgment itself starts on page 58, paragraph 1. So to give your lordship some context for the claim, paragraph 1, your lordships will see that halfway through the paragraph, the parties invited me to deal first with an issue as to whether the provisions of Part 36.17.4 should apply. I dealt with this by way of an oral ex tempore judgment, which I pause to say isn't unfortunately available, concluding that the Part 36 offer was relied on was made less than 21 days before trial, and therefore 36.17.4 didn't apply by virtue of Rule 36.17.7c. I draw that to your lordship's attention because I have to acknowledge that anything that Mrs. Justice Yip, as she was, said in this case is therefore obiter on the question of the effectiveness of a Part 36, because she'd already ruled it wasn't a Part 36 offer effectively because it was made too late. So you'll see at paragraph 2 she's giving her judgment in the exercise of the general discretion under Part 44. But if your lordships turn forward to page 62 and paragraph 15, there's a brief summary of the nature of the claim. It's described as a complex clinical negligence action in which there were numerous overlapping issues on liability, set out in paragraph 33 of the substantive judgment. There were also many quantum issues. Determination of some, but not all of the quantum issues, depended on my findings of breach and causation. And perhaps importantly, given what's said in the case of Cashman, which I'll turn to shortly, liability and quantum were tried together. So this wasn't a split trial case, it was a rolled up trial. Mrs Justice Yip's analysis of the Part 36 offer to the extent that it assists starts at paragraph 31 on page 66. And at paragraph 31, she sets out that she's already dealt with the question of its applicability because it was made less than 21 days before trial. But in the indented section, the terms of the offer are set out. And I signposted this to your lordships earlier in my submissions. This is an offer on liability, meaning a breach of duty and consequent absence of benefits of paragraph 4A in the particulars of claim, and presence of injury consequent upon the January 2012 surgery. The claimant offers to settle for 80% of damages following a finding of liability. So, in other words, it's exactly what the court had recommended by way of approaching Seabrook. This court had said, be specific about exactly which elements of causation you are making an offer in respect of. At paragraph 32, Mrs Justice Yip, as she was, says that there was some dispute as to how that offer was meant, or indeed whether any clear meaning could be discerned. But she said, looking at the context of the case as a whole, that it was plain to her that the claimant was seeking 80% of the damages assessed on the basis of the defendant's breaches caused the serious complications after the surgery in January 2012 and the loss of the benefits of a successful surgery. The terms of the claimant's offer fit with my view as to the target of the claim for damages. It also lends support to my view that this is not a case where the claim has only been partially successful. So the court didn't have any difficulty with the nature of a Part 36 offer, which was a percentage offer, but not just a percentage offer in terms of liability, a percentage offer in relation to two particular aspects of causation. So far more complicated than in the Mundy case or in this case. And at paragraph 39, on page 67, the court said, I also take account of the liability offer made by the claimant, albeit at a late stage. It was made a little too late to be considered an effective Part 36 offer. She says that she doesn't know the extent to which the trial costs have been incurred after expiry, but she says, I've set out my interpretation of the offer above. Given the limited impact the consent issue had on the damages claim, even if it was viewed as 80% of the losses attributable to every pleaded allegation, it still represented a better outcome for the defendant than the resultant trial. And that, in my respectful submission, ties in with this principle that you will rarely have a case where it is extremely straightforward to compare an offer with an outcome, unless the offer and the outcome are made in precisely the same form, whether they're both money offers or they're both liability offer determination or agreement. But the fact that the offer and the outcome may be expressed in different forms doesn't render the offer an ineffective offer by reference to Part 36. What it simply requires is that the court engages in a relatively summary analysis in some cases. In other cases, it might be more detailed as to whether or not the outcome is more advantageous than the terms of the offer. In some cases, it will be obvious whether it is or it isn't. In other cases, it will be less obvious, and it will require a degree of analysis on the part of the court charged with that task. So this idea, and I drew your lordship's attention to the words, particularly in Mundy, that there needs to be a like comparison, I say respectfully is wrong. There needs to be a comparison, but it doesn't need to be like for like. It doesn't need to be in precisely the same form as the outcome. And to the extent that I need to make good that point, there are three authorities in the bundle. If I can take, or if it would be helpful to take your lordships to any of them in particular, I'm more than happy to do so. But I'll perhaps say this. The three authorities are Grant and FR Acquisitions, which is sometimes referred to as Re Lehman Brothers That's at page 77 of the bundle. There's Lamport and Jones, which is at page 111 of the bundle. And Rahman and Hassan, which is at page 21. And if I can perhaps give your lordships a very the briefest of overviews of each of those cases. In Grant, or the Lehman Brothers case, an offer was made in money terms. When the matter reached a trial, declaratory relief was obtained. But the court was quite content to engage in an exercise whereby it sought to compare the financial outcome of the declaratory relief as against the money offer which had been made by the claimant at an earlier stage.
What declaration was suggested?
If I take my lord,
is it hugely complicated?
It is, and I suspect, at least in part, that's my unfamiliarity with this sort of litigation. But
this is not a case of a personal injury.
No, well, the offers are in the tens of millions of pounds.
Yeah, right.
But perhaps to assist, I take your lordships to page 87 of the bundle.
Yeah.
It's the tramlined sections of the judgment. Paragraph 31 is where it starts. And you'll see the second issue as it's identified is the test under 3617.2, which is the test that should be adopted in determining whether the declaratory relief to which I have held the administrators are entitled is at least as advantageous, and more particularly whether the arithmetic test, by which that's a reference to the in money terms, at least more advantageous in money terms. Paragraph 33 perhaps gives some indication as to the nature of the declaration, being whether the sums specified in the swaps will become due on the termination of the administrator's appointment. The declaration is now sought and obtained in terms require payment of money as soon as the relevant steps are accomplished, subject to the theoretical possibility of a supervening event of default. And perhaps without me trying probably rather ham-fistedly to explain the full analysis, your lords will see at paragraph 35 onwards, and particularly perhaps paragraph 39, that there is an extremely detailed analysis of interest rates and the application of interest to certain sums.
You want it's the beginning of 38, isn't it? My purpose was to double check.
Yes.
That in mathematical terms, the payments required by the declaratory relief will exceed the amounts of the offer.
Indeed.
Yes. And your submission is not binding on us, but it's indicative of the way that a judge has addressed non-congruent offers and outcomes.
My lord, exactly.
Yeah.
Exactly.
Okay.
The conclusion of 43.
Yes, my lord, that's the conclusion, that having gone through that exercise of trying to compare an apple with an orange, the court was comfortable in concluding that the offer was at least as advantageous as the outcome. The Lamport and Jones case is a similar point. I don't propose, unless it would assist, to take your lordships to it particularly. That was a case concerning a right of way. An offer had been made which was non-monetary. The relief that was granted was non-monetary, and the court engaged again in the idea or this fairly straightforward concept of, well, now we need to try and analyse whether or not the outcome, which is not in money terms, is more beneficial than the offer that was made. What it does say, which is perhaps helpful, is on page 126. Paragraph 79 on page 126. And without reading paragraph 79 and 80, it talks about the test being open textured and permitting of a wide ranging review of facts and circumstances in deciding whether the judgment, which is the fruit of the litigation, was worth the fight. In non-monetary claims, where it's only ever a non-monetary claim, of course that's the only way in which an offer can be analysed. 17. I accept that we're in slightly different territory here because this is a money claim. But it demonstrates that the court shouldn't find, as Mrs. Justice Collins Rice did, the idea of a comparison between forms of offer and belief as an insurmountable problem. The final case was Rahman and Hassan. I don't think, with respect, that says anything different to the two cases to which I've already referred, but it is a very recent example in 2024 of the court undertaking that exercise.
I'll ask you, you've very helpfully taken us through the pertinent authorities, but
yes,
what we haven't actually done is look at the rules.
Yes, of course.
I just wondered whether when the rules themselves demonstrate some of the difficulties with Justice Collins Rice's analysis. We've already looked at the fact that Part 36 offers can be made in relation to issues.
Yes.
Which may not be immediately translatable into money.
Yes.
But when we look at the nature of offers and look at Part 36(5), sub 4, Part 36 offer which offers to pay or offers to accept a sum of money will be, etc. And the same with 5. Now, that seems to me to clearly anticipate that some offers will not be to pay or accept money. And then again, when we come to 36(17) 2, it provides for the purpose of paragraph 1 in relation to any money claim or money element of a claim, more advantageous means. Well, again, that means there may be elements of the claim which are not money elements.
Well, my lord, that must be right.
And in which case you aren't looking then at better in money terms solely for the answer.
My lord,
don't the rules themselves provide us with at least strong indication that her approach was not right?
Well, they do indeed. And I say that there is much to be taken from the words in 36(17)(1, either A or B, which is that the court is concerned with whether or not the offer or the outcome is more advantageous. And that's, I say, an intentionally broad phrase.
Is there a definition of money claim?
No, I don't believe there's a definition of a money claim. My understanding is that that term is used to describe any claim where the remedy sought is financial, either in whole or in part. the final point on Monday is a short one, page 17 of the bundle. At the top of the page, which is partway through paragraph 41, the line beginning incentivising the avoidance of liability trial. The judge said this: it makes a 90-10 liability offer into a means for a claimant who fails to beat a money offer to settle his claim, to recoup a substantial premium for winning the case nevertheless. It's an attempt at a unilaterally imposed insurance policy to reverse the losses otherwise provided for by 3617. It is, in other words, an attempt to use 3617 against itself, contrary to both its letter and its spirit. And she concludes in paragraph 42 that trying to do that strains the language of the provision, undermines its careful balance, and introduces a degree of complexity and uncertainty which she wasn't persuaded was within the rule's contemplation. My lords have my submissions on the idea of the spirit and the principle underpinning Part 36, and parties are encouraged to make offers of exactly this type. But on this question of whether or not this is an inappropriate tactical move on the part of a claimant to seek to try and insure against the risk that matters go against it at trial, well, I say respectfully, that's precisely what Part 36 is designed to do. That is the carrot and the stick that I referenced at the beginning of this judgment. And your lordships may see that at the top of page 18, Mrs. Justice Collins Rice says, it may be, in other words, that in a simple case like the present, they are all carrot and no stick. And if that's the result, it seems to me to be inconsistent with Part 36. Well, I say respectfully again, that's the opposite of what Part 36 is designed to achieve. It is designed to encourage parties to make offers. It gives an incentive to parties to make offers, and it incentivises recipients of offers to take them very seriously. Because if an offer is rejected and it turns out it was a good offer, then there are consequences, and that's the stick.
What do you say the correct order for Mrs. Justice Collins Rice to have made was on the facts of Monday? Very early, claimant 90-10 offer. Defendant 12 months later offers 4,000. At trial, damages 3,800.
It seems to me there's probably two possible scenarios. The most convenient is almost certainly that the claimant recovers the Part 36 consequences up to expiry of the defendant's offer. So they would be entitled to costs on the indemnity basis from the expiry of their own offer until the expiry of the defendant's offer to settle the whole of the claim, which was subsequently beaten. Now, I appreciate there's a difficulty in that because while that deals with indemnity costs and interest on costs and interest on damages, it does leave rather unanswered the question of what the court would do with the additional amount, the 10% bonus that one's entitled to, 10% of the damages.
It does leave an interesting question. If there's a 90-10 liability offer, and then the defendant makes a monetary offer later, not having accepted the 90-10,
yes.
Then what are they doing? Because they've had an offer to accept only 90%. So if they're making a monetary offer on a 100% basis,
They should have been accepting.
then they should have been accepting the 90-10.
Yeah.
If they're making it on a 100% basis, then what is wrong with saying, well, you should have accepted liability and then made an offer on...
What the defendant's doing is skinning the cat in a number of different ways. They'll be thinking, well, we've got these risks on liability, we've got these risks on quantum. We want to settle this case. 2,000 is not going to do it. 2,500 might. It won't be anything more sophisticated than that.
Well, I suppose it's case specific. In Monday, what seems to have been a possibility is a 50-50 liability split. So there was a concept, there was a possibility whereby the, sorry, forgive me, no, I'm mixing the cases up.
Yes.
In Monday,
Monday
of the split.
holiday
Yes.
food poisoning
Yes.
case is not going to be contributing to
No.
negligence. There might be causation.
Yes, forgive me, I was confusing with Seabrook,
Yes.
which was the road traffic accident case. So the defendant, as Muddle indicates, is thinking about different ways in which this might pan out. But the reality is that on the facts of that case, it was really an all or nothing liability. It was 100% or nothing in most circumstances.
A defendant who makes an offer is offering to accept liability, at least to a certain percentage.
Yes.
And I entirely accept that it may not be a fixed concept of what percentage and what percentage of, and what quantum.
Mm.
But nevertheless, there is nothing wrong in an analysis which said, well, in accepting that liability, or accepting that you will accept that liability, you could have accepted the defendant's liability offer. Now, if you get, the claimant's liability offer, if you go to trial and ultimately it is established that you are liable for more than 90%, but that the damages are less than the 4,000 that you offered,
yes,
then what is wrong with saying you should have accepted liability and you should be liable for those costs? You have beaten the quantum, so you will get Part 36 remedy in relation to the cost of the quantum exercise.
From the date of the offer, from the date of the quantum offer.
Yes.
Yeah.
well, that would certainly be a route that would be available to the court, and I'm persuaded. But I can see the merits in that. I suppose the defendant's option, if it was taking the view in a all or nothing case, that £4,000 was an appropriate amount of damages. I can't quite see why a defendant wouldn't accept the Part 36 liability offer, and then in the same breath say, and here's an offer for quantum. We think it's £4,000, less 10% is 3,600.
Well, maybe because they think that if they go to trial, they will do better than 90%.
Yes.
Or do work that they'll.
Which would work if there was a realistic prospect of a percentage liability finding, but on the facts of Monday,
yes,
where there wasn't that realistic prospect, in fact, that was a finding of the judge that they had pled contributory negligence, in fact, and the court said, well, that's a nonsense pleading on the facts of this case. It would never happen. It's an all or nothing. So in another case where that liability outcome is a possibility, where there is a realistic chance of a percentage liability order, then yes, the defendant could choose not to accept the liability offer, but to make a Part 36 in money terms to settle the whole. Or, of course, they could make a Part 36 offer to settle the quantum. So if it's accepted, it doesn't settle the whole claim, but it resolves the question of quantum subject to the question of liability. That's, I described it before as the purpose, but I suppose in one sense that's the principle lying behind the party's ability to make offers in respect of different elements of a claim.
Can one fashion a Part 36 defendant's offer to say, we're not making any concession on liability, but the damages to which any apportionment of liability should apply, we offer £5,000.
Yes, absolutely, my lord.
You can do that.
Absolutely, you can, because the issue in the claim that you would be offering is the value of the claim, the quantum of the claim.
On a 100% basis.
On a 100% basis. So you could say that liability remains in dispute, but we offer to agree that the value of the claim is £5,000, subject to any decision or agreement in respect of liability.
Yeah.
And again, that's entirely ordinary. I'm trying to think back, and perhaps Mr. Barnstable can help me while I'm making this submission. I think in one of these cases, when the matter got to court, quantum had already been agreed in one of the authorities. And it's entirely ordinary to attend trial and open by indicating to the court liability remains in dispute, but we've agreed quantum. So that's well within the gift of defendants or indeed claimants to make those offers.
Right, so sticking to Monday and Tui for the moment, if the defendant had said, when making the offer, we accept 90/10 and we are offering you 4,000. The claimant goes to trial and gets 3,800.
Yes.
Defendant clearly gets costs from the date of the offer.
From the expiry of the offer, yes.
The expiry of the offer. Because quantum is by then the only live issue. The
Yes.
defendant has done better. If the defendant, as they did, says nothing about liability, offers 4,000, claimant only gets 3,800, then you would accept the defendant must be entitled to the costs of quantum from the offer, but you would say not to the cost of liability.
Well, I started my reply to your Lordship's question by saying there are two possibilities. The first I addressed your Lordship's on was the split in time, so that one party gets Part 36 consequences up to a point and the other party gets the consequences thereafter. But there are two authorities in the bundle which address this question to some extent, and one of them is Webb, which is a decision of this court, and the other is London Trocadero, which is a High Court decision, which in time followed Webb. Now, if I take your Lordships to Webb, which starts on page 142, and the relevant paragraph is paragraph 30 onwards, starting at 152. Paragraph 30, the first question is one of construction. In the version of Part 36 immediately before that current in April 15, the words were his costs on the indemnity basis from the date on which the relevant period expired. I think that the meaning of this paragraph was clear. His costs meant all of his costs. The masculine possessive pronoun was deleted when the CPR was made gender neutral, but this could not have been intended to alter the effect of the paragraph or the costs denoted by the word costs. On this basis, a successful claimant is entitled to all of her costs on an indemnity basis unless it would be unjust. So that case considers and deals with the question of, well, actually, you don't have the indemnity basis award only in respect of the cost of liability, for example. If the offer was only in respect of liability, it is all of the costs, unless it's unjust. And the spectrum of circumstances in which it might be unjust to award indemnity costs in respect of all of the claimant's costs will be varied. But at one extreme, you might have a case which is exclusively about liability because quantum's been agreed, and a liability-only offer. At that stage, you would recover all of your costs. There might be some very small bits of quantum perhaps that weren't agreed, but in substance, the matters are all about liability.
So we spent a day on issue X on which you failed. You should never have pushed it, therefore that bit is disallowed.
Yes.
But otherwise you get your costs.
In that sort of circumstance, yes.
Yes.
On the other end of the spectrum, you might have a Part 36 offer that was in respect of a minuscule element of the claim. So in this case of Monday, there was, I think, £50 for miscellaneous expenses. If the claimant had made one offer which was a Part 36 offer to accept £10 for miscellaneous expenses and was awarded 25 at trial, it would frankly be a nonsense to give the claimant Part 36 indemnity costs in respect of all of his costs when the offer was made in respect of such a small, minor element of his claim. And that's where the test of injustice is a useful safety net, a safety valve, if you like, to ensure that justice is achieved between the parties. But the starting point is that it's on all of the costs. The second authority, and it's a High Court decision, so of course it's not binding on this court, starts on page 199, that's the Trocadero case. And the issue is addressed at paragraph 55 on page 205. And your lordships will see that the judge, Robin Voss, sitting as a High Court judge, Chancery Division, was had his attention taken to Webb. Paragraph 55.
What's this?
I'm so sorry.
About
page 205.
Yes, but
And it's paragraph 55 of the London.
what is it? Oh, arrears of rent and service charge.
Yes. Mr. Trompeter submits, based on the wording of 3617, that consequences must apply to the whole of the sum awarded and the whole of any costs. Mr. Trompeter did refer in passing to the decision of the Court of Appeal in Webb. However, he accepted that this was a case where the Part 36 offer related to the whole of the claim, and so does not provide any assistance in relation to the effect of a Part 36 offer which relates only to part of a claim. Just pausing there, I'm not sure that's quite right, that Webb, the Part 36 offer in Webb relates to the whole of the claim, but perhaps relatively little turns on that. A paragraph 60, the judge gives an example similar to the example, I suppose, that I just gave to this court. He says, where a claimant brings a claim for a total of £1 million but makes an offer in respect of part of the claim worth 100,000, can it be right that the defendant does not accept that offer and the claimant is successful in relation to the whole of their claim? The defendant is liable to pay the additional amount of 75,000 based on the £1 million total, rather than a figure of 10,000 based on the £100,000 to which the Part 36 related. This would, in my view, be wholly disproportionate. The result of this is that, in my judgment, the references to 3617(4) to the sums awarded and to the costs must be interpreted as references to sums awarded or costs, as the case may be, in relation to the part of the claim in respect of which the Part 36 offer was made. That's a possibility which is open to the court, it seems to me, but it's a tinkering with the automatic consequences of Part 36, which, pursuant to this court's decision in Webb, the starting point is that you would be entitled to indemnity costs, which means all of the costs of the claim. But ultimately, it's within that discretion that Part 3617 affords the court to make that order, unless it would be unjust. And it would be unwise, I suspect, for me to stand here before your lordships and try and give 7 or 8 examples or more of different types of circumstances where different orders would be required to achieve justice.
Does it make any difference? Because in some of the cases we've been looking at, they were multi-track claims with lots of money involved. So that the effect of 3617 is, if the claimant is the winner,
Yes.
the claimant gets indemnity rather than standard costs and 10% surcharge and so on and so on. Whereas in a personal injury case being tried on the fast track, the effect of bringing yourself within 3617 is you is this right? You come out of the fixed cost regime and you go to the old style regime, costs to be assessed if not agreed. Is that the effect of it?
That would be the effect.
Yeah.
There are a few points which arise from that. The first is that the rules themselves don't create a carve out for different cost regimes.
36.
36 doesn't
yeah.
give me, yes. So it would have been within the gift of the rule makers to say, this is the rule in respect of cases to which the fixed cost regime doesn't apply, and this is a different set of rules where it does. They don't do that. The second point is that the decision of this court in Broadhurst and Tan, which is in the authorities bundle, gives effect to the provision that Your Lordship, Lord Bean, has just indicated. That has been around for some time. Broadhurst was decided by this court in 2016. We're coming up to the 10-year anniversary. There have been no changes to the rules to create that carve-out in the time since Broadhurst was handed down. But perhaps most importantly, the outcome in Broadhurst is a proportionate one. So where a defendant runs a case to trial when they ought to have accepted a Part 36 offer, if it was made very close towards the trial, then the period of time within which they'll be paying standard basis costs is very small. If an early offer is made and they plough on regardless and incur thousands or tens of thousands or more in costs in the interim, put the claimant to that expense when they ought to have accepted an offer, then the period of time within which they're paying standard basis costs is commensurately larger. Excuse me. And it's worth, in my respectful submission, remembering, try and turn up the authority.
Sorry, so just going back to what you just said now.
Yes, of course.
In this case, the 90-10 offer was very early.
Yes.
But if a 90-10 offer was made, say, 2 months before the trial,
Yes.
and the claimant does better than that, wins at trial,
Yes.
the effect of 3617 would be limited to the time from the expiry of the offer.
That's right.
And before then, a claimant would only get fixed costs. Is that
Yes.
right?
That's right. So Broadhurst, I can take your lord to the relevant paragraphs in a moment.
Yes.
Broadhurst provided that where costs are to be assessed on the indemnity basis, they are out with the fixed costs regime. But you would be entitled as the claimant in that scenario that your lordship illustrates. The claimant would be entitled to fixed costs, the fixed costs that were payable at the point at which the offer expired, plus indemnity costs from the day after expiry until the claim concluded. Yes. If your lordships will forgive me a moment, I'll make good that submission by reference to Broadhurst. It's page 197. Rather conveniently all in paragraph 31. As we have seen, Judge Robinson, that was the judge below, considered that Parliament could not have intended that a claimant should recover indemnity costs in a Section 3A case, that's a fixed cost case, because of the practical difficulties that such an interpretation would entail. I accept that there are bound to be some difficulties of assessment where the costs are partly fixed and partly assessed, but I also accept the submission of Mr. Williams and the written submissions of Mr. McQuater on behalf of APIL that these were overstated by Judge Robinson. Where a claimant makes a successful Part 36 offer in a Section 3A case, he will be awarded fixed costs to the last staging point provided by the relevant rules and table. He will then be awarded costs to be assessed on the indemnity basis, in addition, from the date that the offer became effective. This does not require any apportionment. And it's perhaps worth carrying on to finish that paragraph. It will, however, lead to a generous outcome for the claimant. I do not regard this outcome as so surprising or so unfair to the defendant that it requires the court to equate fixed costs with costs assessed on the indemnity basis. As Mr. Williams says, a generous outcome in such circumstances is consistent with Rule 36. That's 14, then it's now 3617 as a whole, and its policy of providing claimants with generous incentives to make offers and defendants with countervailing incentives to accept them. The carrot and the stick.
Yes. Thank you.
So for all of those reasons, my lord, unless I can assist the court, so sorry, forgive me, I can't recall whether I drew your lordship's attention to the PGF case. I think we may have strayed before I got there. Page 179. Your lordships may recall we were considering the paragraphs in Monday where the learned judge has concluded that it was that the claimant, by making the Part 36 offer that he did, was seeking some form of litigation insurance against the risks of an outcome which was adverse. And I contended that that's precisely what Part 36 was intended to do. That's to make that.
Sorry, where were you reading from?
Sorry, I was summarising what the judge said in Monday. I can take your to the
Yes.
paragraph in Monday first. Page 17. Perhaps if your lordship's keeps page 179 open, I'll go back to that very quickly.
Monday, page 17, paragraph.
Yes, paragraph 41. It's at the top
Thank
of the
you.
page. I've taken your lordship to this before,
Yeah.
so I won't read it out, but it's this idea of recouping a premium for winning unilaterally imposed insurance, which is a policy to reverse the losses otherwise provided for in CPR 36, an attempt to use 36 against itself and contrary to its letter and spirit. You needn't take my submission that that's an inappropriate categorisation of Part 36, because this court in PGF made that point. Page 179 of the bundle.
No,
Paragraph
just
21.
looking at what the case is about.
Yes.
Proceedings for breach of repairing covenants. Does that mean it's just damages, not any?
I believe it was damages.
Yeah.
Yes, paragraph 6 on page 177 talks about the values. There were Part 36 offers ranging from 1.125, paragraph 8, going over the page, paragraph 11, an offer of 700,000, and then paragraph 17 might be considered particularly relevant given what comes next. The claimant's response by email later the same day was to accept the defendant's Part 36 offer of 700,000, thereby settling the proceedings, save us to costs. And paragraph 21 on page 179. The Part 36 is itself designed to encourage parties to make and promptly accept realistic offers of settlement, fairly to be described as lying at the interface between litigation and ADR, reference to Matthews and Metal Improvements and SG and Hewitt, which are two decisions of this court about when circumstances change after a Part 36 offer has been made, should the Part 36 consequences be visited upon the late accepting party. And then it says, Lord Justice Briggs, I should say, says, it may, for example, be used by a defendant to encourage its opponent to accept a lower offer than its own valuation of the claim on account of the claimant's limited appetite for cost risk. It is a procedure frequently used by parties determined to pursue litigation to trial precisely for the purpose of obtaining one or more layers of insulation against the cost risk arising from an uncertain outcome. So, precisely the concern that Mrs. Justice Collins Rice had being recognised by Lord Justice Briggs as a perfectly legitimate use of Part 36 in the context of litigation.
And it's the general remarks you get from this case, and just glancing at the headline, it seems to be a typically messy case where there's some revelation on the day of or the day before the trial that the particular claim isn't well founded, and that makes all the difference, and so on.
Yes, I think on the facts of this case, it was there were £350,000 between the offers by the start of trial, and on the morning of trial, one of the parties introduced a new issue with a value of about £250,000, and that prompted the acceptance. There is one final authority I ought to refer you to extremely briefly, and I will do it briefly because it seems to me that really there's relatively little left to say about the position in Monday. But it's Chapman against Mid and South Essex NHS, starting on page 250 of the bundle. Now, this case post-dates Monday, which was understandably brought to the attention of Mr. Justice Hill when he was given this decision. His analysis of it, to the extent that it might assist this court, is at page 262 onwards.
I think you'll find it's her analysis.
I'm so sorry. Her
Dame
analysis.
Henrietta.
I do apologise.
Yes.
It starts at paragraph 29 on page 262 and runs just slightly over the page. What Mrs. Justice Hill did in that case is to distinguish Monday on its facts on the basis, well, on a number of bases, but particularly on the basis that this case involved a split trial. So there was a liability trial. But in my respectful submission, whilst I say Mrs. Justice Hill reached the right conclusion, it was unnecessary to distinguish it from Monday on that fact, because in my respectful submission it would be a nonsense if that was the determinative factor, that you could only have an effective Part 36 offer in respect of an issue which would itself be subject to a standalone preliminary issue trial or a split trial of its liability. So for the reasons I've already addressed at the court, I say that paragraph 3617 doesn't limit effective Part 36 offers to that category where that issue and that issue alone will be tried separately. And indeed, I say that you can see that in the approach of the court in Welsh, Mrs. Justice Yip, and in London Trocadero, where there were rounded up trials, not split trials, and yet the Part 36 offers were effective. So for all of those reasons, I contend, with the greatest respect to Mrs. Justice Collins Rice, who wasn't shown at any of the authorities at which we've considered in detail today, other than the Seabrook case to which she was referred briefly, that her decision in Monday was wrong. And consequence of that is that the learned judge, Honour Judge Baddeley, who on the first appeal in this case found himself bound by that decision, he was wrong to find himself bound by it, and that his decision on appeal ought to be set aside. His judgment is in the authority, is in the appeal bundle. Page 138.
We're getting first, because Mr. Ralph will be saying, never mind Judge Baddeley, that the discretion was exercised by Deputy District Judge.
Yes, and I accept we're in slightly unusual territory here, because the Part 36 argument wasn't taken before the Deputy District Judge, but permission was granted to take that point on the first appeal.
Yes.
So in fact, the first person to consider whether or not the Part 36 offer had been, or the outcome was more advantageous than the Part 36 offer, was the Circuit Judge, Judge Baddeley. And so, unless I can assist your lordships by looking particularly what the Deputy District Judge said, it seems to me that what the Circuit Judge said is more helpful.
All right, well, let's go to that now.
Okay. So it's page 143 where it starts, paragraph 25. And you'll see at paragraph 25, the judge introduces it, turning to the second ground of appeal, that being the Part 36 point. All that the Deputy District Judge said was that neither offers bite. And his determination, paragraph 28, sorry, I should say let's deal with paragraph 27 first. Having set out 3617 in the rule, Mr. Turner, for the claimant appellant submission, is that the claimant beat his 90% offer, said this case would always have settled on quantum, and that the issue that took the case to trial was liability. At the door of the court, the defendant 100% capitulated and made a full liability offer. It reminds me that the transcript discloses no discussion of a discount for litigation risk or contributory negligence when the case was put to the Deputy District Judge for approval.
But Mr. Turner, that's not right, is it? There was no concession of liability.
No, I accept that.
And the question I have in my mind, which I'm sure you'll come to, is can you demonstrate by reference to admissible matters
Yes.
that the settlement must have, by necessary implication, because it wasn't done expressly, amounted to an acceptance of liability? Because otherwise, just what's troubling me is you haven't got a finding on liability.
Yes, I will address you on that, of course. And the slight nuance I would put is the claimant doesn't have to demonstrate a finding on liability, which is a like for like
Accept
in
that.
the same form. It simply has to demonstrate.
Yeah. Well, we haven't heard Mr. Ralph, but at the moment I'm minded to accept that.
Yes, he has to demonstrate that he's achieved an outcome which is more advantageous than his offer.
Well, what the rule says judgment.
Judgment, yes. So there are two questions. One, is there a judgment? And I know that my learned friend says there isn't. And if there is a judgment, if there isn't a judgment, then Part 3617 doesn't engage. So that's the first.
Well, where is the judgment?
Well, I say the judgment is the order of the Deputy District Judge.
Where? Show me in the order.
Well, should I deal with the Monday point for the Circuit Judge first, very briefly? Few seconds.
Sorry, yes.
Whichever way round you like.
Yes, thank you. I think it will be easier for jumping around the bundle. So paragraph 28 on page 143, Mr. Kay, who sits behind my learned friend, referred to the words of the rule, more advantageous means better in money terms, refers to the judgment of Mrs. Justice Collins Rice, and your lordships will see at paragraph 30 that the learned Judge Baddeley concluded that he was bound by the decision in the Mundy case. He also made a conclusion that the defendant never conceded liability, which is the point that I'll go on to deal with now. So, to the extent that the judge in the first appeal considered himself bound by the decision in Munby, I say, if you're with me, that Munby was wrongly decided, then his decision on that point needs to be overturned. Turning to the question of judgment, I say that the judgment in this case is the order made by the Deputy District Judge, which is on page 146 of the bundle.
So not the transcript, just
Not
just
the transcript, the order. Yeah.
Just the order.
Well, I suppose to some extent it would depend on your lordship's view as to whether or not a decision was required, which is a point that my learned friend takes. And I'll address that.
Well, it has to be a judgment.
In the course of this argument. It has to be a judgment. Yeah. And the question then is, well, what is a judgment? And I say that's a less straightforward question, or certainly a less straightforward answer, than one might expect at first blush.
Well, in a simple case of a damages claim with a, say, contributory negligence defence, the judge in their reasoned judgment might say, I find 25% contributory negligence. But the only order that will be made will be you pay
Yes.
7,500 rather than 10,000.
Yes.
So looking at the order wouldn't tell you what the percentage of liability was. You'd have to look at the reason.
Yes.
To find that. And the judge, when he came to deal with costs, would know what his reasons were, his or her reasons were. So there, the judgment, it seems to me, must encompass the judge's reasoned judgment.
Yes.
Mustn't it?
In that example, yes, it does.
But there is no reasoned judgment here.
Well, there is a judgment, in that sense, there is a reasoned judgment. The transcript demonstrates that the judge considered whether or not to approve the settlement which had been reached between the parties. That required her to exercise her discretion and to determine whether or not the proposed settlement was an adequate amount of damages.
Yes, but no reasoning as to whether or not, on liability.
No reasoning on liability, no. I accept that.
And she didn't need to because it was a settlement.
Yes, indeed.
So,
but what I
so
say is
settled rather than determined by the court.
Settled rather than determined by the court, yes. I accept that.
So there was no judgment at the court as to what the liability was.
No judgment on liability. Yes. But what I say is, if one looks at Part 36.17 and what's required, and it might be most convenient in the authorities bundle to look at page 278, just towards the back, which is the extract from the White Book. So 278, subparagraph 1 of 36.17, the rule which I referred to throughout my submissions. This rule applies where, upon judgment being entered, a claimant fails to obtain a judgment more advantageous than a defendant's Part 36 offer. So if I take any number of the examples that we've had where we don't have a like-for-like offer and outcome, if I take, for example, the Lehman Brother case, the offer was in pounds and pence. The award was for declaratory relief. So dealing with the two questions, first of all, the question of judgment, there needs to be a judgment of sort, and I say that this order was a judgment. The second question is, there needs to be an outcome which is at least as advantageous as the offer. And I say that doesn't mean, in the example of this case, that you need a judgment on liability. You just have to have a judgment which, properly considered, is a judgment which is more advantageous. It doesn't have to be in the same form.
Give me 146. I just can't see a judgment.
Well, let me address you on that.
Before you do,
yes,
if I may be, can you identify for us what you say are the necessary characteristics of a judgment within the meaning of 3617.1.
Yes,
Because then we'll understand what you're looking for in
indeed.
the order.
Indeed. So it's page 275, back
Yeah.
a few pages, which is the notes, or the rule at 40.1, and then the notes to that rule. Excuse me. And I do have some authorities to take your lordship to on this point as well.
Yes.
The notes at 40.1.1 are a useful summary of the way in which, or the history of the use of the word judgment. And your lordships will see at the second paragraph, or rather in the first paragraph, 40.1.1, under the RSC and the CCR, a judgment was the final decision of the court in civil proceedings. Such a proceeding was an action. It talks about the distinction between an action and a matter depending on the venue, and then says that a final decision of the court on a matter was not a judgment but an order. A decision of the court in an action or in a matter other than a final decision was also an order. Second paragraph, the technical distinctions between a judgment and an order were derived in part from the provisions defining some of the terms of art referred to in the previous paragraph, as found in the definition provisions in the Senior Courts Act and the County Courts Act, and in the RSC and the CCR. Once upon a time, the distinction was important when it came to enforcement, but that ceased to be the case a long time ago, and dicta to the effect that it is doubtful whether there is still any distinction between the two terms have to be seen in that context. One important reason for distinguishing a judgment from an order disappeared with the definition of judgment for the purposes of enforcement came to include any judgment or order. And your lordships will see that one of the cases cited in what comes next is Knight against Rochdale Healthcare, which I'll take your lordships to very shortly. But before I do, over the page.
Well, you just stopped just short of whether found in the CPR or in other legislation, whether primary or secondary, have to be defined in
Context, yes.
So, would you accept that it's at least theoretically possible that the word judgment has different meanings in different parts of the CPR?
Yes, I accept that entirely.
Okay, thank you.
Over the page, the first substantive paragraph, I'm picking that up partway through the paragraph, the line that begins with the blue text, DWHC 1831. It remains to be seen whether anything important has been lost and whether any unwelcome problems have been caused.
Sorry, where?
I'm so sorry. About halfway down the paragraph, the first substantive
Oh, I see.
page 276. It remains to be seen whether anything important has been lost and whether any unwelcome problems have been caused by maintaining in the CPR the expressions judgment and order when it appears that one is not a synonym for the other, but yet no basis for distinguishing between them can be derived from the rules themselves. Neither expression is mentioned in the interpretation provisions of the CPR at 2.3 or in the glossary. It could be argued that under the CPR, a judgment is a final decision of the court in a claim and an order is any other decision. The concept of final decision arises under the CPR in the context of appeals. And then it talks about Part 70. The expression judgment or order is given an extended definition. The practice direction, Part 26, which deals with allocation and reallocation, it's given a restricted meaning. So that picks up the point that my Lord Justice Stuart-Smith identified, that it's a malleable concept which is required to flex to meet the underlying intention which underpins its use in a particular rule. Turning then to the authorities, my learned friend in his skeleton argument says that the claimant's reliance on Vanden recycling is misplaced, but doesn't develop, and I've no doubt my learned friend will develop that when he's on his feet. But I say that the Vanden case is directly on point, recognising that it doesn't relate to Part 36, but it does demonstrate that in certain circumstances where it's appropriate, an order for damages can amount to a judgment. So the Defendant
for my purposes, when looking at these authorities,
yes.
I'd really like to know what, so I understand the context, what is it on page 146 you say is a judgment? So we can understand what we're trying to look at.
Well, I say that there are a number of elements to it. So the order provides at paragraph 1 that the claimant may accept the sum that's offered, which is a necessary requirement under Part 2110. And then at subparagraph 3, there's an order that the damages be paid. Now that follows the analysis of the approval that's put to the judge in the transcript, and she gives a decision as to its appropriateness. That's on page 171. Now, if this court took the view that it was necessary for the judge to have made a decision which gave rise to a judgment, then I would rely on paragraphs 1 to 3 on page 171, because that's the point at which the judge concludes that she can and should make an order for damages in the claimant's favour. But if I'm, I don't, my primary case is, this doesn't turn on whether or not the claimant's a child, because if that were necessary, then it would only be a judgment in a case where there's a child or protected party which requires the court's approval under section or part 2110, and I can see the prima facie difficulty with that. I say that any order which provides for the payment of damages, a judgment by consent, is a judgment for the purposes of part 3617, and I say that the Vanden case helps me to make good that point.
All right, let's have a look at that.
So Vanden starts on page 42. It involves a claim that's compromised by a consent order, and the consent order is set out on page 47, starting on page 47. At the bottom of that page, page 33, paragraph 33. The trial is between the claimant and second defendant presently fixed to commence is vacated. Paragraph 3 of the consent order, the second defendant is to pay the total sum of £275,000 in full and final settlement of the claimant's claims against the second defendant in these proceedings with interest and costs. It goes on to deal with what happens if, in the continuing action against other defendants, there's a recovery in respect of costs. It then at paragraph 4 purports to stay the proceedings. I say purports for reasons that will come clear very shortly. And there's some other provisions in respect of the mechanism of payment. Now your lordships will see at paragraph 43 of the judgment, which starts at page 52, this court's analysis of whether or not that consent order amounted to a judgment. In that case, for the purposes of sorry, forgive me, I'll come back to that point. So at paragraph 43 on page 52, Vanden contends that the consent order is not a consent judgment, but is simply an order giving effect to a compromise agreement, and falls to be considered in the same way. If so, the critical issue is whether that agreement intended to fix the full measure of Vanden's loss, and it's admitted that it's clear that it was not so intended, because it created the carve-out for recovery of costs from elsewhere. In particular, it stressed that Clause 3 uses language of a compromise agreement rather than a judgment. Clause 3 contemplates proceedings will continue against other parties. And Clause 5 provides that the use of materials disclosed by Bolton in respect of the continuing claim against the first and third defendants. Crass contend that the intention is irrelevant, whereas is the case here, one is ascertaining the effect of the judgment. The latter automatically has effect whatever the parties intended, because it's an order of the court of the same status as one made after trial. And I say that that's the position here. If, for example, the defendant had not made payment in accordance with the Deputy District Judge's order, that order could be enforced. It has exactly the same status as an order that's made at the end of a trial. There's reference to Mr. Justice Ramsey's decision in Care North East, which draws a distinction between a Tomlin order, where the effective provisions are in the schedule and do not form part of the court's order, and a consent order, where the effective orders are within it. And that analysis or comparison is continued in paragraph 45. Notes that a breach of consent order may be punishable as a contempt in appropriate circumstances, whilst the remedy for breach of scheduled terms in a Tomlin order is a claim for breach of contract. Variation of a consent order is possible in the interest of justice, with rectification would be necessary to vary the whilst rectification would be necessary to vary the contractual terms of a Tomlin order. It goes on. There are a number of differences between the two in paragraph 45. And then the relevant or most useful paragraphs in my respectful submission are paragraphs 46 to 50. And they warrant consideration in full. In the White Book commentary at 40.1, which is the commentary I've just taken your lordships to, there is a discussion as to the meaning of a judgment or an order under the RFC and CPR. It's pointed out that although the CPR refers to the two terms, sometimes in conjunction and sometimes not, no basis for distinguishing between them can be derived from the rules themselves. As Vanden points out, the consent order is expressed in similar terms to a Tomlin order. It refers to Bolton being required to pay sums in full and final settlement, and it purports to stay proceedings except for the purpose of enforcing and carrying out the terms. It's clear, however, that it is not a Tomlin order. A Tomlin order involves a contractual settlement agreement and allows for proceedings to be continued for the purpose of carrying out that agreement. In the consent order, the settlement terms are part of the court order. Enforcement does not require any further proceedings. Application can be made directly to the court to enforce the terms of the order it's made. Although the consent order purports to stay the proceedings, there are in fact no continuing proceedings to be stayed. Vanden already has a court order which can enforce for payment. And there is no further order to be obtained other than in relation to enforcement. If one has regard to what the consent order does rather than what it says, it requires Bolton to pay a specified sum in respect of Vanden's claims. As far as those claims are concerned, it is a final order, and I say respectfully that that's an important point. If there was a judgment for Vanden on its damages claims following a trial, a court order for payment in similar terms would be likely to be made. Although the consent order does not use the wording of adjudication or judgment, the order it makes is to the same effect as one which would be made following a judgment. Just pausing there, of course, it was within the gift of parties to any piece of civil litigation to agree a consent order which says judgment for the claimant in the sum of X pounds. I respectfully say it would be very difficult for my learned friend to say that's not a judgment when it's couched in those terms. And the Vanden, the Court of Appeal, this court in Vanden, made clear that just because it doesn't use the word judgment, if it is, to all other intents and purposes, a final order, made in precisely the same terms that an order would be made at the end of a trial, then it is a judgment.
Forgive me, I understand that. One reason I wanted to ascertain exactly what you were saying was,
Yes.
was the judgment is. I mean, the more difficult question, it seems to me, is why is that more advantageous than 9
Yes.
to 10?
That's the second
It's a
question.
different point, isn't
We'll
it?
get that.
Yes.
But
It's an important question, and I can see why the court will be vexed by it. I hope I have an answer which is to the satisfaction of your lordships.
well, can I just take you back? Because I asked you what the necessary characteristics of a judgment were
Yes.
for the purpose of 3617. And one definition would be an utterance of the court, which is the source of obligation.
Yes.
So in Vanden, the consent order, you can see on page 47, the source of the obligation to pay the £275,000 is the order of the court. And it goes beyond, for the purposes of Vanden, which was about whether the other tortfeasors were out on it, by saying it's in full and final settlement and so on and so forth. In this case, the source of the obligation to pay is the settlement between the parties. And the only function of the court is that that settlement is not valid unless and until the court validates it.
Well,
And they can do that.
Sorry,
Yeah.
I'm going to say I entirely disagree, but
Okay,
if,
well,
you
that's
put
good.
if you put the point to Mr.
But
Latham first, and then I'll say why I disagree.
if that's right, which clearly probably isn't, but if that's right, you can't. There's no the approval by the court simply says the settlement is valid, and that's the source of the obligation. I think I've just repeated myself.
No, not at all. I have the point. I don't know if it's better for me to keep my powder dry and hear.
Well, all I was going to say is surely the source of the obligation is paragraph 3 of the order. The defendant shall pay damages.
Yes.
Claimant
Well,
solicitor.
But that would be my submission. It won't at all surprise anybody
Yeah.
to hear. But I develop it slightly further, which is to say this. One has to take a step back and look how the case would be concluded if it were two capacitous adults. It would still require a consent order unless there was a Part 36 offer and acceptance which stayed the claim on terms.
I wouldn't. You could do the two adults of full capacity settling for 2,650 could walk into court and say, "We've settled, full stop. That's it. You're not interested at all." Because they might frequently say, "Well, can we have it in a Tomlin order
Or a consent order.
or a consent order?" But the source of the obligation to pay is their settlement.
Well, I suppose the point there would be if that was the route that they adopted, it would be foolhardy, I respectfully suggest, because if the terms of the agreement were not met, then the aggrieved party would have to start new proceedings for breach of contract. Whereas if they walk into the court and say, "We've agreed 2,650, can you enter judgment by consent on those terms, or make an order by consent in precisely the same terms in Vanden, that the defendant's to pay sum of X in full and final settlement."
Well,
And of course,
just to make clear the width of the disagreement between my lord and
Yes.
myself, I don't think in paragraph 2 the reference to damages is apposite. Should have said the settlement sum.
Well, save that. There isn't just advantage to the claimant in recording the terms of the agreement in a consent order, in terms of enforcement and not having to start new proceedings. There are advantages to the defendant because the defendant is given good discharge of the claim that's brought against them. And as we've seen, or as we will see, forgive me, in a case I don't think I've yet taken your lordships to. In fact, I haven't. It's a case relied upon by my learned friend. By compromising a claim which is pled or pleaded in terms, it precludes the claimant from bringing another claim on the same basis. And so the defendant, in reaching agreement like the defendant did in Vanden, in terms that, forgive me, I've turned the page over. The settlement is in full and final settlement of the claims against that defendant. It compromises all of those pleaded allegations. And so the reason I say it would be foolhardy, not just for a claimant to walk in and say, please judge, don't do anything at all. Arguably the court would still have to do something. They'd have to dismiss the claim if it was to just be terminated rather than leave it sat in abeyance or strike out the proceedings or strike out the claim. Or they'd have to, in my respectful submission, do something with it. But even if I'm wrong about that, both parties would be well served by having a consent order which records the terms of their agreement, both from an enforcement perspective for a claimant, but also from good discharge from a defendant.
You have some settlements where the parties don't want the court to know, don't want anybody else to know the terms of the settlement. That doesn't alter the underlying fact, which is that the source of the obligation is the settlement. And then you have a question whether to put it in Tomlin order and not show the court the schedule and things like that.
Well, I respectfully submit that the source of the obligation, I accept that the source of the obligation may, at least to begin with, be the agreement. But if that agreement is formalised in an order, then that is a judgment of the court. And I respectfully suggest that would have to be recorded in some way or another, either in a Tomlin order, which brings the proceedings to an end, or in a consent order, which brings the proceedings for an end for all to see, and on terms that all can see. But if I perhaps develop that by reference to Vanden and the other case that I say makes good that point, which is Knight, the case referred to in the notes to part 40. I was reading paragraph 49. I think I've just come to the end of that. But in answering your lordship's question, my lord, as to the features of a judgment, it seems to me that paragraph 49 of Vanden helps with that, because it talks about, in the second sentence, as far as those claims are concerned, it is a final order. And I say that is a feature of a judgment for the purposes of Part 36. Not that it has to terminate the entire claim, or bring the entire claim to an end, because of course you could have judgment on a preliminary issue. But it's a final order in respect of the issue to which it relates. That, I say, is the feature of a judgment. And if there was judgment for Vanden on its damages claims following a trial, a court order for payment in similar terms would be likely to be made. Although the consent order does not use the wording of an adjudication or judgment, the order it makes is to the same effect as one which would be made following a judgment. And then in paragraph 50, since in substance and in effect, the order for payment made by the consent order is the same as would be made following a judgment, I consider that the judge was correct to conclude that it's to be treated as a judgment for the purposes of the rule that satisfaction of a judgment bars claims against tortfeasors liable for the same damage. So it's a procedural rule. It's a different rule to Rule 3617, but this court is saying in clear terms, this is to all intents and purposes a judgment. It's a final order, it's by consent, and it doesn't follow a decision of the court.
It's a pity there wasn't a liability issue.
Indeed,
Part 36 in Vanden.
Yes.
I take that point. The other case is Knight, and that starts on page 104. This is not considering the terminology in the context of a procedural rule, it's in the context of a provision under the Limitation Act and, in fact, the Contribution Act. Excuse me, the Civil Liability Contribution Act. The relevant paragraphs are on page 109 paragraph 21, right at the bottom. And Mr. Justice Crane said, I accept that in 1978, when the section from which at present section 10 was derived was passed, a judgment in such an act would not necessarily include any court order. The use of that word, especially in conjunction with the words held liable and given, clearly points to the kind of order by which liability is imposed. However, that conclusion does not dispose of the matter, because it's accepted by both counsel that the description consent order is not necessarily conclusive. In other words, if this was in reality a judgment, it would not cease to be so by calling it an order. Although a consent order in the form used here is the usual form in such circumstances, the parties could have agreed that judgment be entered by consent, and so drafted a document placed before the court. In my view, this consent order, a final order in the litigation, could properly be described as a judgment for the purposes of subsection 3. So we have another example of a circumstance where it isn't a decision of the court, there isn't a judgment of reasons, if I call it that. There is a consent order, which doesn't say judgment for the claimant, but which is a final order for damages concluding the claim. And the court, High Court Judge, Mr. Justice Crane, concluding that for the purposes of the Civil Liability Contribution Act can be a judgment. And that's why I opened this submission by saying it's perhaps not as clear cut as one might think what is a judgment for the purposes of Part 36.17, and we look to the purpose which underlines the rules. This is designed to give teeth to the incentive, the carrot and the stick, that Part 36 as a regime is intended to create and enforce. And in my respectful submission, those teeth would be somewhat blunted if a defendant can accept an offer out of time, Part 36 offer out of time, which would mean that an agreement or an order for cost is necessary. And by creating a consent order, which doesn't use the word judgment, can subvert the underlying principle of Part 36 and the consequences of them not having accepted for possibly a considerable period of time an offer which they should have accepted some time before. And both Knight and Vanden are supportive of the proposition that a consent order, whether it uses the word judgment or not, which records the parties' agreement, a final judgment, final order in respect of the part of the claim to which it relates, can be considered a judgment for at least two different purposes. One, procedural rules, one for interpretive of a statutory provision. And I invite the court to consider this hypothetical. If proceedings were issued and a defence wasn't filed or acknowledgement of service wasn't filed, judgment would be entered by default. There would be no reasoned decision of a court. It's an entirely administrative task. Nobody would argue that that wasn't a judgment. So it's clear in my respectful submission that the key element of a judgment is not that it sits having been produced following a reasoned decision by a judge, but rather that it's a final order in respect of the element of the claim to which it relates, which may be the whole claim or it may be an issue. And that underlines the purpose of Part 36, to which I've already made significant reference.
So that's determinative of the issues to which it relates.
Yes.
So
if
which
it was
allows the possibility of a partial judgment.
Yeah.
A judgment of part of the case.
Yes. So if, for example, there had been an order for a split trial and then the parties compromised that, it would be recorded in an order. And indeed, there are often at that stage orders for the decision, orders for the agreement on liability, often applications for payments on account of the costs of the liability. And
when that was done by consent, you wouldn't argue that that was a judgment?
I would.
You would?
If it's done by consent.
You would?
It's a judgment, yes. If by consent the party said judgment for the claimant for 50% of the damages as assessed, that would be a judgment in my respectful submission. because it's a final order in respect of the issue of liability. But I say it doesn't need to use the word judgment. It could, and one often sees that word being used by consent, judgment for the claimant, X% of damages to be assessed. In my judgment, that is in my submission, that is a judgment.
Okay.
And so I move on then, if I may, unless there are any further questions, to the question of, well, on the facts of this case, is there a judgment? For the reasons I've already set out, I say there is. But I perhaps just make one small point, which is the point my learned friend takes against me, that there shouldn't be a difference in the way in which claims are treated depending on whether or not the claimant is a capacitous adult or a child or patient. And I say, if the court's with me on this point, there isn't a difference. If the court were to accept that Vanden and Knight say a consent order agreed and filed with the court by two capacitous adults is a judgment, then it must, in my respectful submission, follow that where a claimant who is a child or a patient, a protected party, is not capable of signing a consent order but requires the court's approval, then the court's approval, in exactly the form that we see, page 146 of the bundle, is properly interpreted with the same weight as a capacitous adults agreement would be. And arguably, it's even more likely to be considered a judgment because it has had some judicial input and a decision. And that brings me on to the next question and the final question, which is, if you're with me that Monday was wrong, if you're with me that there's a judgment, that this is a judgment, is it a judgment that's more advantageous than the Part 36 offer that the claimant made? Well, you have my submissions on the fact that the fact that there's a difference in form, that one's a liability offer, one's a pounds and pence outcome, is not determinative or too troublesome. What the court would then have to do, and I accept that no judge has yet done that in this case, but what the court, I say, would have to do is then perform an analysis of the outcome, the judgment, and the offer to determine whether or not the offer is more advantageous than the outcome. And that's why I say that the claimant in this case doesn't need to demonstrate that there was an agreement on liability, because the question for the court is not whether or not there was a judgment on liability. The question is whether the pounds and pence that were agreed is more advantageous or less advantageous than the offer.
How can you possibly know that when the parties have reached a compromise and they may have had completely different reasons for reaching it? One may have said 50% of X, and the other may have said 95% of Y.
Well, it's slightly easier, ironically, in this case, because we have the transcript of the approval hearing.
But why is that? Why does that
only help?
The judge has to consider whether to approve that as a settlement for the child.
Yes.
He's not considering in any way. What is the reasons behind that figure.
Not considering the reasons behind the compromise, I accept. But under Part 21.10, the court is required to have regard to whether or not liability is admitted in whole or in part. That's in the authorities bundle at page.
Well, the answer is it wasn't.
Yes. So when one looks at the transcript, perhaps it's easiest for me to make the submission by reference to the transcript of the hearing below, which is on page 147.
Forgive me, this is one of the reasons I want to pin you down as to what's the judgment.
Yes.
That is not the judgment you're relying on.
Not as the judgment for the purposes of 3617. I'd say that's the order.
Yeah.
Is the judgment.
So when one was looking at whether the judgment is more advantageous to you, why do we look at the transcript? Because
the court, if you're with me on the judgment point, then the question for the court under 3617 is the outcome, the judgment, more advantageous or less advantageous than the Part 36 offer that was made. Now, if the Part 36 offer was £1 and pence and the judgment was £1 and pence, it's very easy. That's a question which requires no real analysis. But in this case, we have I've been calling it a difference of form. So the offer is in one form, percentage terms. The outcome, the judgment, is in a different form, pounds and pence. And so the court needs to exercise its discretion. It doesn't make the Part 36 offer ineffective. We dealt with that in Monday. So we have an effective Part 36 offer and an outcome. And the court has to compare the two and decide which is more advantageous to the claimant. That won't always be straightforward. And indeed, in the Grant case, the Lehman Brothers case, you saw the judge over a number of paragraphs calculating interest and various other factors to decide whether an outcome in a different form to the offer was more advantageous or not. I say on the facts of this case, and I have to be clear about what I'm asking this court to do, none of the judges below have addressed this question of whether or not the Part 36 offer was more advantageous. Because before the district judge, it wasn't contended that the Part 36 offer bit. And in front of the circuit judge, he said, Monday binds me, it's not an effective Part 36. So there are two ways in which this court could deal with that question. It could remit the question back to the district bench, or it could deal with it in its judgment, whether or not the outcome is more advantageous to the claimant than the offer.
Well, I think in the first instance, though, whatever was said, I mean, what troubles me is how it's conceptually possible to do that exercise where it's a settlement. Because
ultimately, it's a question of fact. It's a mixed question of fact and law as to whether or not the outcome is more advantageous. So it's a determination that will be made by a judge.
But this is where one has the difficulty with the only offer you made being in relation to liability.
Yes.
Because the offer on liability, at the end of a trial, you can see whether or not that has or has not been beaten. The judge can decide it.
Yes.
Has to decide it.
Yes.
But where there's a settlement, there's no decision in that regard. There's not even any agreement in that regard. It is entirely at large as to on what basis this figure has been reached. And
Yes.
so all that we discussed before of being this going to an issue, and the issue is liability and a percentage split, that just hasn't been decided, agreed, or even in any way necessarily thought about. So I don't see how anything that can be said in the transcript, unless the parties have said what the basis of their agreement was, which they didn't, how it in any way helps.
Well, my answer is this. If we take an extreme example to make the point, this was a 4-month injury to the finger. The valuation was always likely to be reasonably modest. If the parties had agreed a figure of £50,000 and came into the court and said, we've agreed £50,000, can you approve it? It wouldn't take any district judge very long to conclude that the 90-10 offer had been bettered by the pounds and pence.
Well, that's because your claim
far
form
more.
said £3,500.
Yes, so it's far more than the claim would be worth. That's the extreme example. But there will be other examples, and I say that this is one of them, where, and this is why I was going to take your lordships to the transcript, the court in this case, the Deputy District Judge Khan, had to determine whether or not to approve the settlement. And in doing that, there's a few pages, and I didn't propose to take your lordships through them all, but a few pages where the court's taken to the medical evidence to establish the extent of the injuries, to the Judicial College guidelines to indicate what the value of the damages would be for a 4-month finger injury with a full resolution thereafter, and then is invited to find, as a matter of their discretion and judgment, that the sum of £2,650 is an appropriate sum. If that was to be determined by reference to the fact that liability remained at large, and there was therefore a liability risk to be factored into that figure, then you would expect, first of all, the court to be told that. But more importantly, that's a crucial element to any court determining a compromise on behalf of a child. which doesn't reflect 100% liability because it reflects the litigation risk. And that's why it's one of the particular factors in CPR 21.10 that the court needs to be told about. So in other words, if we saw here the judge saying, well, I've looked at the medical evidence, I've looked at the Judicial College guidelines, and in my view, on a 100% basis, this case is worth £3,000. However, liability is not agreed, there's no admission, it's not compromised, and there's a liability risk. Therefore, I think £2,650 is the appropriate sum. Then no doubt she would have said that. But the fact that she isn't given any information, she isn't told that there is a liability risk, she isn't invited to consider the figure that's put to her as a reasonable settlement figure by reference to the fact that there is a liability risk, means that it's abundantly clear when one reads the transcript that she's assessing whether that's an appropriate level of damages for the claimant on a 100% basis.
It doesn't mean it's more advantageous than what you offered.
Well, if the judge concludes that that's the right figure on a 100% basis, then it stands to reason that what's being recovered is more money than would have been recovered if the offer had been accepted and the claimant was recovering only 90% of his claim.
All the court has to do is be satisfied that the settlement which is presented to it is an appropriate settlement.
Yes.
Not the best settlement, not the worst settlement, but within the range. And I have to say I share my Lord's difficulty, but can I put it in a slightly different way?
Yes.
I can't at the moment see how you define the advantageousness of the offer.
Well, it's more advantageous in money terms is the requirement in the rule.
Right. And
So
how do you define the offer as it was made? The only element of the offer that you've got is 90-10.
Well, if my Lord was right about that, then it would mean that the offer had to be made in the same form as the ultimate award.
No, it just means you haven't got a judgment which demonstrates that you've done better than it.
Well, forgive me, let me put it a slightly different way. In the Rahman case, before His Honour Judge Matthews, the offer was to accept certain chattels within a property, and the conclusion, the offer at the end, or the outcome, was that he wasn't entitled to those chattels, but he was entitled to 2 flats instead. It's not a straightforward question as to whether or not that outcome is more advantageous than the offer that the claimant made, because it requires the court to engage in a degree of investigation as to whether or not, either in money terms or in non-money terms would be appropriate in other cases, that outcome was more advantageous. I don't accept the starting point from a line of friends submissions in writing, that it has to be immediately clear to everybody. It has to be plain as a pikestaff whether or not the offer has been beaten. That obviously has advantages. But if one looks at the Lehman Brothers case, if one looks at the Rahman case, if one looks at the case that begins with an L, forgive me, the other case I referred to, which is Lamport and Jones, the court in each of those cases got to the end of the case, whether by agreement or court order, judgment, with reasons, and said, right, I now need to decide whether or not this is an outcome which is more advantageous than the offer. And in none of those cases was that question resolved within a paragraph. In all of those cases, it required an examination of the circumstances. Now, in a low-value case such as this, the extent of that examination will need to be proportionate, and it's likely to be very modest. And it may well be that in certain cases, and this might fall into this category, that what you'd expect a judge to do is look at the case as if they had, for example, an advice from counsel, which they would normally do, had it not settled at the doors of court, and say, well, actually, I think this case is worth £2,500 or £2,700, and therefore the figure that's been awarded is or is not more than 90% of the value of the claim on my assessment. That is a decision which is a mixed question of law and fact. Under 3617, is the outcome more advantageous? And it has to be determined on the balance of probabilities, and I'm bound to accept that there will be cases where a judge will say, I can't be satisfied on the balance of probabilities that this is an outcome more advantageous. It would be disproportionate to have any other form of investigation into that question, so I'm against you. Take the extreme example of the much larger case, or the case where it's very plainly, obviously, a significant recovery over and above. Let's say, for example, a claim limited to £1 million, and there's a 50-50 offer of liability, and the parties come in and say, we've agreed £750,000. It equally wouldn't take much investigation into those circumstances, not knowing how the offer had been made, how it had been analysed, how it had been structured, for a court to say, well, that's obviously a better outcome, a more advantageous outcome, than if the defendant had accepted the 50-50 offer a year ago. Because if they'd have accepted the 50-50 offer in a £1 million liquidated damages claim,
Yes.
the best that they could hope for was £500,000.
Well, that's much easier than our case.
Yes.
I see it's 1:10. It's been a pleasure listening to you, but we had rather hoped you might finish by lunchtime. On the other hand, the second party can usually go a bit faster because we looked at the cases.
Yes.
Can you think about over lunch whether you need another 5 minutes after the break?
I will.
And if you do, you shall have them. But then I think the baton ought to pass to Mr. Ralph.
Very good, my lord.
All rise in table.
Oh, can I just raise one thing? Do we have the claim form?
Yes, it's in the bundle.
We've got the particulars of claim,
Oh,
but I'm not sure. Anyway, could we have them at 2 o'clock? Thanks. Whatever you say, my lord.
We'll take 10 minutes after lunch break, 2 o'clock.
thank you.